elder law，有人讲这 elder law 是你是讲教会长老，我讲唔知嘛，连在遐去啦吼，因为张国清甲我介绍讲，这个律师吼，专门去做这 elder law 的专家啦吼，足侪咱，因为咱毋是直接出生嘛吼，其实这个法律嘛一直去改变，所以咱加减知影一寡咱这个诶。权益吼，佫爱注意物件，拢是袂歹啦吼。所以咱今仔真欢喜张国清吼，张国清是即马北市区台湾同乡会理事吼，伊真欢喜会使甲咱介绍甲咱切身有关系的代志吼。多谢，请张国清来介绍咱的律师。
各位乡亲大家好啊！我叫张国清，英文名字叫 Audrey。我现在是做在纽泽西一个 real estate agent 做地产的。那因为呢，我接触的人比较多，尤其呢自己的年纪也渐渐衰老哈。然后呢，我的服务的人群呢也是差不多也都是一些 senior citizen， 像我这个 generation 的。所以呢，我就去给我自己做一个特别的一个 certified， 就是 senior citizen 的这个 specialist 在房地产上面。那 Corey 呢，他是一个我多年认识的一个律师啊，他也是做 elder law 的，所以呢，我最近跟他请教了一些问题。我觉得，因为呢，我发现说。不仅是我自己非常非常需要啊，而且呢，有很多的地方呢，都是我们应该可以考虑的事情。不管你现在是什么样的年龄，在什么样的光景之下，我觉得我们有一句话说“人无远虑，必有近忧”嘛，哈。尤其说，我想我们大家到美国来打拼这么多年，多多少少存下一些资产，那这些以后，如果说我们不在了，或者是我们当自己不能够自理的时候，那这些要怎么去做个安排呢？所以我就请 Corey， 感谢这个雨欣还有淑理姐的邀请哈，就把这个 Corey 呢介绍邀请到我们中间来。他是一个非常资深的一个律师，这是他的专业，所以呢，我就想请他跟我们下面呢，就是跟我们讲解一下哈。稍微先了解一下，当然其中有很多的窍门，不是我们听了一次就能了解的。不过说呢，可以你等一下私下呢可以跟他请教，或者是还有现在会发一些他的那个 brochure， 可以跟他联络哈。第一次咨询的时候是免费的哈，希望对大家有所帮助。对不起啊，我要替他翻译哈，抱歉，我的台语以前在台湾的时候还可以对付一点了，离开台湾太久了，所以我们还是用中文吧。
我想反正大家都听得懂英文嘛。我们不需要翻中文，不需要中文。
OK，
不需要翻译。
They say they don't use everybody knows English. Okay, so. Yeah, I think so. 还是需要翻译的。
Can everyone hear me?
Yeah.
Hello?
Yeah.
I can hear you. Okay, there we go. Okay, hi everyone. My name is Muchnik, and I'm sure Audrey had introduced me. My practice is based in Randolph, New Jersey, and Staten Island, New York. I practice in both states in estate law and elder law, and I deal with families in both states. And I'm here today to discuss some of the common mistakes that many of our clients make in their estate planning. And I'm also going to talk about how this essentially affects everyone in the room. Okay, so I just want to start this off by asking, by show of hands, who here has children?
你们举手，有小孩吗？你们都有小孩吗？有小孩的请举手。
Okay, and who in the room has grandchildren? Any great grandchildren? No, not yet? Okay, perfect. All right. Soon. So essentially, for anyone who has children or grandchildren or family, okay, this affects you in some sort of way. Okay, why? Because you have worked your whole life, you accumulated a certain level of wealth. Okay, you may own real property, you may have bank accounts, you may have investments. Okay, you worked with financial advisors, maybe accountants, you've done maybe tax planning, investment planning, you've done all these things to set you up for retirement. Okay, and what happens in retirement? Well, now we have to plan for the next phase. We have to plan for death. And it's
我很快的就是介绍一下啊，就是说他刚刚讲的，就是说我们大家都是
拿近一点，
这样可以吗？
对，这样子声音才会到的，然后这样最好是这样，对对。
大家都辛辛苦苦的，
那你关掉了，你关掉了。对。
听得见吗？哦 ，OK， 我听了 ，OK， 好，谢谢，对不起啊，因为大家来美国这么久，都是离经叛变哈，多多少少传了一些资产，有房地产什么什么的，那就是准备我们就是说到了这个年纪黄金年代的时候呢，可以尽情的享用。可是呢，现在就是说有这个是长处，那不长的之处呢，毕竟我们没有人没有说长生不老，永远活到的，所以总要为身后的事情打算。所以呢，这就是那个Curry 要给我们介绍的。
Okay. All right. So where were we? We were talking about in retirement. The conversation is usually what is going to happen in my death or disability. Who is going to manage my affairs? Where are my assets going to go to? Who is going to be my beneficiaries? How are things going to play out with my real estate that I own, with my mortgage that maybe I'm still paying? What is going to happen to me? These are all questions, all important questions that you need to ask yourself. Because at a certain point, someone is going to have to make the decisions. The question is it you, or is it going to be someone who is appointed by the court to handle your affairs, and maybe the person is not the person that you wanted to be in position to handle your affairs? So this is why we have estate planning. Okay, estate planning is essentially planning for the disposition of your assets on death. Who are going to be, as I said, your beneficiaries? Who is going to receive your assets? How are your debts going to be paid? Who is going to sell off your assets? Perhaps you're in a second or a third marriage and you're looking to not leave anything for your spouse and leave everything to your children from a prior marriage. Or perhaps you're looking to make sure that your house goes to your children, but your current spouse gets a right to live there for his or her lifetime. So everyone's estate plan is unique in their own way, but the process starts with asking these important questions. Now, I have a short list of very important documents that everyone in the room should have. And the reason why you should have them early is because in order to be able to sign certain estate planning documents, you have to be competent. You have to have the legal capacity to sign certain documents. So unfortunately, if you have a chronic illness, if you're advanced dementia or Alzheimer's disease or anything that affects your thinking, these documents are no longer going to be an option. And your families are going to be forced to go to court in order to get answers. Audrey, you want to?
我简单的讲一下，他刚刚讲的这么一大段呢，就是说到说，要早早做准备啊，因为呢，不然到时候呢，来个措手不及，你的资产呢，不仅呢没有办法自己控制呢，还要被这个政府机关呢来带你决定啊，谁来继承，谁来管理什么，这就是一个很大的损失。如果说你自己，所以说呢，就是说要打铁要趁热哈，早点做准备。他刚刚给那个发出去的 handout 里面有一些 document， 有一些文件啊，你们可以看一看，这是需要做这是需要填的表啊。是如果说你有要做这样相关的这个规划的话。
And if anyone is lost, the document that I'm looking at is this one page, which should be in the left-hand corner of the folder with a red line on it. Okay? So these are the points that we're covering today. So if you look at the very first document, which is called the last will and testament, we know that as a will. So if someone says, have you had your will drawn up? Have you done a will? This is what they're talking about. Now, what is a will? A will is a legal document where you name a person known as the executor who is going to be responsible for your estate, who is going to distribute assets to your beneficiaries, pay debts of the estate, hire professionals to help with the estate administration and management, such as attorneys, financial advisors, investment advisors, CPAs, accountants, what have you, negotiate debts with certain creditors if they have to, because sometimes there are creditors of the estate, and sometimes an estate could even get sued if a claim isn't paid timely. So a lot of different things you can do in your will depending on what your objectives are. The very important thing to understand about a will during your lifetime is a meaningless document. It doesn't do anything, okay? But when you pass away, for any assets that are solely titled in your name, meaning there's no beneficiary designations, there's no joint owners with rights of survivorship, the will is going to speak for these assets.
我们讲到他遗嘱，什么是遗嘱呢？遗嘱在你有生之年是没有用的，唯一的用处呢是在往生以后。这个遗嘱呢，就是你要分配，怎么样分配你的资产，要怎么样做，你有这个权利，就是你已经不在人世间了，这权利还是你的。
All right, so usually between a husband and wife, each one gets their own will, okay? We don't know who's going to pass first, and usually on the first death, the surviving spouse takes everything because assets are usually jointly held between husband and wife, okay? Whether it's your home, it's usually husband and wife on title. Whether it's a bank account, many of the bank accounts are usually jointly held. Or whether you have a 401k or an IRA, you usually name your spouse as a beneficiary, so there's never a need to use the will on the first death. Okay, so when the second spouse passes away, at that time, most likely there are going to be assets that are titled solely in that individual's name. And now, unless there were children named as beneficiaries, or the accounts were titled jointly with someone and that someone had rights of survivorship, we now have to go to court on the second death in order to commence an estate proceeding. So what does that mean? It could be a probate proceeding. What does probate mean? Probate is essentially where the surrogate court judge looks at your will and he or she says, this is a valid will. Okay, it was properly witnessed, it was properly signed, it was notarized, everything in this document appears to be correct. This document was initialed, every page was initialed, it doesn't look like it was tampered with. I now admit this will into probate. That's what that means. And the executor that you name in your will is now going to receive certificates from the court. These certificates are called letters testamentary. They are special kind of certificates that give authority to the executor to now collect your assets, to take out an estate tax identification number and start proceeding with everything in terms of the administration and settlement of your estate.
这遗嘱如果是这夫妻两个人共同建立的话呢，当第一个先往生的人呢，第二个人呢，他就接着这个遗嘱是不会造成任何太大的差别的。就是你第二个离世以后呢，这个遗嘱呢就生效了。生效了以后呢，当然就按照你其中的一切由这个来执行。所以说就是他刚刚讲的这个意思啊。那你的遗嘱呢会有一个指定代理人。这代理人呢，他要透过法律给他这个 certify， 给他一个鉴定，他是一个合法的指定代理人。 他才可以呢，按着你的遗嘱，按着你生前的意愿来分配你的一切的资产。
他刚是不是说过？他说先生跟太太每个人都应该有他自己的遗嘱。
The husband and wife, they have to have their respective will, or they can have a joint one. My understanding is that have a joint. What do you just say?
So that's a great question. You can have a joint will, but it's not a good idea because a joint will is essentially like a contract. So when your spouse passes away, you can never change it. The will has to be the will. So it kind of locks up the surviving spouse. Now, joint wills are usually a good idea if we have a second or third marriage and maybe we want to make sure that we benefit our new spouse, but we don't want to leave all of our assets to them. And we also want to make sure that when they pass away, whatever assets of mine that they had left goes to my children from another marriage. And maybe in that particular case, a joint will may be a good idea. Usually, I'm not a fan of them because the law always changes. The circumstances always change. When you do a joint will and your spouse passes away, you can't bring him back to make changes. And then you have to go to court and prove that whatever change you want to make doesn't violate the intentions of your spouse who is now deceased. Well, it's not so easy to make a case when your spouse is no longer here. So you want to have an estate plan that's flexible. You know, whenever clients come into me, they ask me how many times over should I make changes, or when should I look at my estate plan if I already have the documents? My best advice to them is whenever you experience a life change, so even if you already have a will, okay, if you have a death in the family, if you have new babies in the family, you come into new money, you move to a different state, anything that's life-changing, you may want to come back to your documents and take a look at them and see if the information that you have there still works for you. Maybe the person that you named your executor is now deceased, or maybe they are chronically ill, or maybe they have so much financial trouble, they're in the middle of a divorce that you don't think it's a good idea for them to be in charge of your estate.
对不起啊，我因为单身多年了，所以我想到的只是我自己啊，没有想到 husband wife 还有这么一个名词啊。谢谢淑玲姐给我们的提醒啊，她这个问题问得很好。那 Curry 他给他的解释说，如果说夫妻二人呢，应该各有一方自己的遗嘱，好不好？那就是说，另外呢，有一个很重要的问题，就是说你遗嘱。不管你不是说你立了遗嘱以后你就一劳永逸什么都不管了，你还要常常回去再看一看。如果说你的这个生活上面或者家庭方面任何资产方面有什么变化的时候呢，你最好去 update 改一下，好不好？按照当时的情况呢，去给它改一下，不同的跟着你的现在的情况呢。去更改。
Okay, so back to the will topic again. You typically have a will signed in the state where you are a resident. So as I mentioned to you earlier, I'm licensed in New Jersey and I'm licensed in New York. You may have a will done in New Jersey and you may end up retiring and moving to Florida or to the Carolinas or anywhere else in the country. And, the typical question I get is, are my documents still good or are they no longer valid? As long as your documents were valid when signed, and if they would be honored within the state where they were done, they will be honored in any sister state in the country. So you don't have to run to another attorney to do everything over. Now, with respect to some documents, you may want to have another attorney take a look to see if any changes need to be made with respect to, let's say, if you had a trust agreement that was set up, and the purpose of that trust was to protect certain assets in New Jersey. If anything was kind of state-specific within your estate planning, you may want to go to counsel in your new home state to see if this particular estate plan still works for you. The other important thing that I want to discuss is if you do decide to move, make sure you don't lose your original documents. because the will, you need the original. And if you don't have the original, you're going to have a problem when anyone in your family goes to court. Because essentially, if the original is missing, the court judge is going to declare that since it's missing, the person must have destroyed it. And then you have to prove that the person didn't destroy it. It was really lost in some sort of move. And perhaps you could make a good case and have a copy admitted to probate, which is usually a very tough kind of task. Typically for my clients, I hold on to all the originals at no cost to them. We have an offsite storage, we have safes, so that this way, if we ever need them, I pull them and I give client copies, but clients lose them all the time. And sometimes they take staples out. And when the court sees more holes than 2 holes in your document, they assume that someone must have snuck in another page and tampered with the document. And then they force you now to get everyone in the family to sign an affidavit that everyone is aware that this document was unstapled and no one had a problem with it. Because things like this do happen. Families do feud. Whenever there's money, sometimes, son, daughter, they feel that they're getting the short end of the stick, even if they're getting 50-50, right? You think 50-50 sounds fair, right? Equal shares. Well, it may not be fair if the daughter had to quit her job to take care of mom. Or if, let's say, the daughter was very well off, has a successful career, owns her home mortgage-free, and the son is struggling. Is 50-50 equal shares fair? It's really up to the family. But as I said, circumstances change. Perhaps the child that was doing very well in life became disabled, and things changed in that person's life. So you kind of have to take this step by step. You have an estate plan done, but certain things can happen that will cause you to come back and make some changes. So that's your will. And, sometimes people ask me, is it a good idea to have a will or a trust? Or should I do both? Or why should I do a will if I already have a trust? Well, the main difference is, as I was telling Audrey earlier, the best way for me to describe what a trust is, think of a trust as an empty box, okay? If you don't put anything inside of the trust does nothing for you. The trust is like a legal entity. It's like a corporation, like an LLC. The trust can own any kind of assets. It can hold real estate. It can hold cash. It can hold investments. It can hold tangible personal property. It can be a beneficiary of certain assets. So essentially, there's different kinds of trusts. But if you do nothing with your trust, then the trust does nothing for you. And even if all of your assets are in trust, even if all of your assets have beneficiary designations, and you know that if you were to pass away today, there would be no need to go to court, a will is still a good idea because you still don't know if potentially there could be, let's say, a litigation on your behalf or on behalf of the estate. What if you pass away when you're in the middle of a personal injury suit and then the case settles after your death? Well, that settlement is going to pay to your estate and someone has to go to court to collect it. And then at that point, the will becomes very important. So in estate planning, I think you should do both. Now, depending on what kind of trust you're interested in, that would really depend on your objectives. Typically, the trusts come in 2 categories. There's your revocable trusts and irrevocable. Well, what's the difference? The difference is simple. The revocable trust, you remain in full control. So you can be your own trustee. The trustee is the person who's in charge. That's the person who's responsible.
他讲了这么多，有问题吗？需要翻译吗？因为他讲的实在太有意思了。他刚刚上面讲了这么多，我大意讲一下，就是说
麦克风。
哦 ，sorry。他刚刚讲的遗嘱，大概的意思就是说，那个遗嘱呢，遗嘱跟这个信托的不同。第一点，他是说遗嘱，你就是搬家，你在纽泽西立的遗嘱呢，你到任何别的州也是可以用。就重要的问题就是说，你不能够遗失 ，OK， 一定要好好保管。你就是如果说很多页你把它订成一起的话，你把它那个 把它拆开来的话，那如果说那个法院看到那个法官看到哦，你这里有这么多的洞，他就会猜疑说你是不是有人伪造文书，把它其中的几页给它挪掉了，所以就很需要很多的麻烦，说每一个人都要签字的家里每一个遗嘱上面的人都要签字，还是家庭里面也是会造成很多的这个不方便啊。然后呢，他现在就讲到说 ，trust 就是一个信托的账户。信托的账户呢，他解释就是说，就信托的账户呢，就是像一个空的箱子，里面什么都没有 ，OK？ 除非你把你的银行的账户啦，或者你把你的房地产的东西啦往里面放呢，慢慢积累了。那你这些东西呢，就是将你在你往生以后呢，可以由你的遗嘱呢来维护这些权益的是这个意思。那遗嘱有2种，一种是不能改变的 ，trust 有2种，是一种就是说一种是呢irrevocable 是不能改变的，有一种呢就是说可以更改的。请说，请问你有问题吗？
我一下
请说。
遗嘱是一定要吗？
Her question is you must have a will.
What happens is, another great question, what happens is if you don't have a will and you pass away, the state of New Jersey decides who gets your assets. And what does that mean? It doesn't mean that the state gets your assets. It just means that if you are survived by a husband and wife, and you have children together, and all children are in common, your surviving spouse takes 100% of your estate. If you're not married and you have no children, but you have parents, according to New Jersey law, your estate is going to go to your parents, which is not necessarily ideal if your parents are much older and could be chronically ill. So the point here is you don't want to leave it to the state of New Jersey to decide who gets your assets. You want to make those decisions yourself. Those decisions are personal to you, and you want to designate the folks that are going to be responsible for your estate. Because let's face it, for those of us that have more than a few children, you may have a specific child who you know is responsible and maybe is more fair than the other children. And that is the person you would want to be in charge. You would not want your children to be fighting over who is going to be the estate representative, because that could easily happen if you don't have a will. So when you have these documents done in advance, these are going to be your last words on this planet Earth, okay? And since it came from you, there's no way your children can dispute your wishes, as long as everything was properly done when you signed these documents. So great question, but again, the point there is you never want to rely on the state to determine who your beneficiaries are, because it's always different depending on who the surviving family members are. And without a will, the estate administration is more expensive, because usually the judge looks at the estate and they're nervous about the person who's trying to be appointed. So they make the estate purchase an insurance policy called an estate bond in order to protect the estate. And this bond, the first premium for the first year is non-refundable. And depending on the size of the estate, it could be a couple of $1,000s just for that bond, because you didn't have a will. So definitely, the planning in advance is what estate planning is all about.
Okay. 遗嘱呢，见仁见智。这其实今天我们所要沟通，大家所要交通呢，都是自己的一个情况。OK， 我们只是就是说给你们一些 information。我个人我现在是跟你讲个人，但因为他是律师，他不能告诉你说你一定得怎么样。那我个人的看见，我的了解说，你如果说你有遗嘱的话，你不在这个人事上面的。你的遗嘱上面所规定的条文是吧？谁要接受这个，这个要给谁，那个要给谁？你有权利，他们还是得尊重你的权利的。所以第一点，你可以避免他们家庭的纠纷，对不对？第二点就是说， 也省了很多的时间，也省了很多的金钱。但是你没有遗嘱的话呢，你们必须去打官司，到法院去，由法院来判决你们该怎么样分这个财产，对不对？那这个呢，第一点，你当然会浪费很多的时间，我们都知道法院的程序是很长的程序。第二点呢，当然也会有很多的财务上的损失。我想对我来讲的话，我最受不了的就是说那个我不愿意他能拿到这个东西的人，他拿到这个东西，我就要从棺材里面跳出来了。OK， 这是我的了解，好不好？哎呀 ，OK， 他对于他们律师来讲的话，他还是会建议你有遗嘱，因为毕竟你有你的决定权嘛，对不对？
All right, so back to trust planning. I mentioned the two different categories. You have the revocable trust and the irrevocable. Revocable means the trust can be revoked. It can be amended. The trust can be terminated. It's almost as if you're taking money from your left pocket and you're putting it in your right pocket. The reason why someone would want to do a revocable trust is to avoid probate, to avoid going to court. If you have all of your assets in a revocable trust, the trust is a private document. It never becomes public information, and your family can settle that trust. If real estate title is held in a trust, the trustee, upon your death, if the trust says that the trustee has to sell the real property, the trustee can make the sale with ease without any kind of court involvement. Usually for folks that own real estate, let's say out of state, so if you have if you're a snowbird and you have a vacation home in Florida or in other states, when you pass away, if your state of residence is New Jersey or any other state, you usually have to do 2 different estate proceedings in order to transfer title to a property out of state. And this is why someone would want to do a revocable trust. So if I had a property in Florida, I could put that title into my revocable trust here, so that upon my death, my family can just transfer the Florida residence or sell it without ever having to go to court in Florida. All right, because a dual estate proceeding means you have to hire 2 different attorneys, one to do the work here, another to do the work in Florida. So typically, there's not too many reasons why someone would want to do a revocable trust, but usually, whenever someone tells me they have a property out of state, that's my immediate, my antennas go up, because I know that it's going to be an issue if they pass away and title is in their name. The irrevocable trust, unlike the revocable trust, the irrevocable means it cannot be revoked. It cannot be changed. You cannot make any amendments. And the reason why someone may want to do an irrevocable trust, there could be a couple of reasons. One, it could be for tax purposes. They're nervous about estate taxes. So they're trying to create a truly irrevocable trust where they take the majority of their assets and they put them into a trust like that, so that upon their death, they're not having to pay any estate taxes. Or, depending on, again, what assets they have, it may be assets that it may not be a good idea to put into a trust. You may have an IRA or a 401k, and these are not the typical assets you would want to transfer into a trust, because these particular assets are based on your life expectancy. So when you place an asset like that into a trust, it could trigger all kinds of tax consequences. But for real estate, bank accounts, investments, for folks that are nervous about estate taxes, they could do estate tax planning. For folks that are nervous about losing their assets to creditors, losing their assets to Medicaid, or needing long-term care, and then, let's say a skilled nursing home suing them, they may want to create asset protection trusts, which I do many of those for many of our clients, regardless of wealth, because I know how devastating it can be for someone who becomes, unfortunately, chronically ill. There's no one in the family to take care of them. Perhaps their wife or, their husband already passed, and the children are not medically equipped, don't have the experience, and the person needs skilled nursing care, and they have to go into a facility. And the issue is, when you go into a facility, for the most part, Medicare, which I'll tell you more about later, which is the typical health insurance for retirees, doesn't really cover long-term care services. So in order to prepare for devastating health issues, we prepare asset protection trusts so that these assets can be protected from the state in the event we have to qualify you for public assistance in order to pay for your health care. And as I said, people hear Medicare and they think, oh, I'll never qualify. You have to have very limited income, assets. I have clients who have a couple of million and we still qualify them for Medicaid because we place their homes, their bank accounts, their investments into a trust. And as long as it's been more than 5 years since we've done it, no one can ever reach that asset. And we help qualify them for public assistance even still. So the bottom line is, I mentioned to you earlier, you work hard your whole life, whether it's in the old country or here, and you want all of your assets, whatever you have left, to go to your family, to make their life easier, to make your grandchildren's life easier. The last thing you want is to use all of your life savings to pay for your health care, because Medicare, as I said, does not cover long-term care. So the trusts, again, depending on what the objectives, I can't tell you what works for you and what doesn't. I would have to individually sit down with every one of you, which I don't think is going to happen today, to see if any of the trusts, if trust planning is a good fit for you. But in most cases it is, because I can tell you, usually we set up a lot of these trusts for the real estate. Why? Because real property is the one asset that somehow is always continuing to go up in value. Even now, the inventory is low. Ask Audrey, she's on the ground level. She sees how crazy things are. It's only been worse since the pandemic. And because this asset becomes so valuable, you may eventually need to tap into it and use it for your own retirement. And this is absolutely an asset that you would want to protect, because it's typically, for most families, their home is their biggest and most valuable asset. So the trusts and the wills, just so you understand, these are two kinds of documents that are really a plan for death, a plan for distribution of assets on death. The other two documents that you see here, such as the healthcare proxy, living will, power of attorney, that's a plan for your disability. Okay? So the power of attorney, you'd sign a document like this in advance so that if, God forbid, you become disabled.
I know.
Do I have a new translator? So the power of attorney, is it okay to continue?
Yeah.
Okay. So the power of attorney is another document that you do in advance where you designate an agent to handle your business financial affairs. You name, let's say, your child or your spouse to handle your banking, your real estate, your insurance, your retirement assets. You have a document like that signed so that if you are no longer able to handle your affairs, you have an agent, a trusted individual who can now take control of your finances and start paying your bills and managing your life. A document like that is extremely important, because if you don't have a power of attorney, okay, for most folks that need someone to get into their shoes, to go to their bank, if you don't have a power of attorney, we now have to go to court. And whenever you go to court, it's always an expensive process. It's always a long process. You will never hear the end of it. With a guardianship proceeding, which a guardianship proceeding is required when there is no power of attorney. If you have dementia or another chronic kind of illness and you no longer understand anything, we have to go to court to have someone in your family appointed your guardian. And if they are a guardian over your assets, they now have to account to the court every year, showing the court how they are managing your assets. More than that, whenever a big decision is to be made, let's say they want to sell the real estate that you own, they have to go to court and ask for permission. So the whole point of the power of attorney is to completely keep things private and keep the court out of it should you ever need to trigger this power of attorney, so that your agent can use it to handle your finances, your investments, and other financial affairs. The healthcare proxy, on the other hand, is your medical power of attorney. So that is where you designate an agent to handle your medical decision making. So the agent can talk to your doctors, can request medical records, can give consent to certain emergency procedures, or refrain from giving consent if you're not able to. Okay, but just so you understand, a healthcare proxy is not just something that's specific to retirees and elders. I drew up healthcare proxies and powers of attorney for college kids because parents, okay, young parents, older parents were nervous about their children going away to school. The children are 18 and now they can no longer speak for their children. They can no longer speak to the children's doctors. So in order to continue their parental rights, they have their children sign a power of attorney in a healthcare proxy, which we've done a lot of them because in the face of the pandemic, parents were extremely nervous with COVID, with the state lockdown. Children are going away to school. All of a sudden, there's another outbreak. Everybody's getting sick. So, it's not just for retirees. As soon as you're 18, you are legally capable of signing these documents.
他这里讲的这一段呢，就是说我们刚刚头先讲到遗嘱跟你的 trust account 这两个都是为了我们往生以后不在人世上面呢所设定的、所准备的。可是我们还在世的时候，我们总是要想到说，人有旦夕祸福，对不对？如果说你今天摔一跤，然后或者是你今天有个什么这个中风啊，或者什么这个特别的状况，让你的这个自主能力或者在你的这个脑力上面呢，都会变成一种障碍的话呢，这个时候呢，你没有办法自己自理 ，OK？ 在这以前呢，在这些事情发生，我们未雨绸缪。他现在讲就是未雨绸缪，在这些事情发生以后，以前呢，你就要准备有个法定的代理人。就是说，当你呢自己不能自理的时候，你中风了，或者是你智障了，或者有任何方面的你的这个精神状况啊不好，没有办法自理的时候呢，这个法定代理人呢就可以替你做主。你要什么样的医疗医疗 OK？ 你要去哪个医院看什么医生什么的，他可以帮你来做这个决定。如果说你没有这个你没有这个条文，我们知道到医院去，你动过手术干嘛？他一定要家属签字，对不对？或者是那可是如果说你没有这个法定代理人，没有这个家属的，这个时候呢，就会出现很多的问题，你不能够，这个医院呢也不会接受，要让这个法院呢来替你做决定。那我们知道，一上了法院，第一点时间给你浪费了，对不对？第二点，它就是一笔开销，对不对？这个的话，所以说呢，一个法定代理人也是很重要。那法定代理人不是说只有到年纪大的时候，你在年纪的，他说他手上有很多的年轻人，他们也就开始有这个法定代理人。Again， 这个人都是吃五谷杂粮的，谁也不知道明天会发生什么事情。所以他现在跟我们介绍，就是你有一个法定代理人。能够在你自己的医疗的程序上面替你做主。
Okay. The one important thing I want to leave you with respect to the powers of attorney and healthcare proxy, many married couples don't realize that just because you're married, it doesn't mean you have the legal authority to speak for your husband or wife. I want to tell you a quick story. This was a case out of New York, and there's several like this in New Jersey as well, where, husband and wife lived together. The husband had a heart attack, collapsed. The wife calls 911, and the ambulance comes there, and they're asking the wife if she has a healthcare proxy. She tells them no. So then they proceed to tell the wife, well, we have to take your husband immediately to so and such hospital that's a mile away. And she tells them, no, you can't take him there. You have to take him to another hospital that's 1.5 miles or 2 miles away, because that hospital, all the doctors there know him. They have all of his records. So what do you think the ambulance staff said? They said, well, no, if you don't have a healthcare proxy, our protocol is to take your husband to the nearest hospital. So guess what? They took the husband, they brought him to the nearest hospital. None of the doctors there nothing in their database. They didn't know nothing about this individual. They didn't know he was a diabetic. They didn't know what medicines he was allergic to. The guy almost died just because they had no record of him in this hospital, okay? So that is an eye-opening, rude awakening, so to speak, because again, your husband and wife, that's your trusted partner, your better half, your other half. You would think that, they can speak for me. Well, no, because the medical protocol, because of litigation issues and other things and certain rights that people are scared to cross the line, the ambulance folks, the emergency personnel, they have a protocol. And if the person who's speaking for you doesn't have the authorization in hand, they're not going to talk to that person regardless of who that person is. So this is why these documents are extremely important to have in advance. And probably most of you have seen a healthcare proxy at some point. The hospitals usually have you sign something. And usually the documents you see in the hospital are only good for that one facility. So in other words, if you go to a doctor with that document or you go out of state, the document is not going to be honored. It's not going to be accepted. The documents that I prepare are legal documents. And because I stand behind them and you had an attorney prepare them for you, they will be accepted anywhere in state or out of state, which is important because you could be on a road trip and in a bad accident. And you want to make sure that the documents you have that were good, let's say in New Jersey, are also going to be accepted in states like Pennsylvania. Okay? So this is pretty much a quick summary. There's plenty. It's not just irrevocable, revocable. There are many different kinds of trust. I don't want to keep you here all day, but typically this is my immediate go-to. If there's property out of state, they want to do a revocable trust, or maybe they don't trust their children and they want to be in control of their assets. So we do a revocable trust. Irrevocable if we want to protect their assets or if we want to do some sort of advanced tax planning. All right. So we talked about the documents up to this point. Point number 2, even for people that had their documents already prepared, as I mentioned to you earlier, it's a good idea to revisit your estate plan every 5 years or so, especially if there is a life change. I can tell you back in the 90s, a lot of our clients maybe had documents that were done 20, 30 years ago. In the 90s specifically, the wills did not need to include a document called a self-proving affidavit. So it's an affidavit that your witnesses would sign. And if you don't have that affidavit at the time of probate, the judge may force you to now locate your witnesses from 30 years ago. Imagine how are you going to locate these witnesses? They were working for the attorney. The attorney already closed up his practice. The witnesses are probably not even alive, and it becomes a major issue. So even if you already have an estate plan, make sure your documents are up to date. The one thing I do is, I should have mentioned this earlier, all of my initial consultations are free. Okay, if you have estate planning documents, I'm happy to look at them and give you my opinion to see if maybe you need to make any changes, or maybe your documents are still work for you. So after today, you have any questions and we don't get to them, always feel free to reach out to me. My information is in the folder. So jumping to point number 3, we want to be very careful about who we name as our executor in your will, as our trustee in your trust, or as your agent in your power of attorney or healthcare proxy. Because this person is going to be making decisions that are going to have some serious consequences for you and for your family that maybe are not going to be undone by a judge because there's no legal solution. So whenever you designate someone, you have to make sure that that person is, number 1, willing to act in that role, because sometimes, you may name your daughter, but you never told your child that you named them as an executor. And maybe they don't even want to do it. They don't want to get involved. So it's very important to have this conversation with your family, which is not a great conversation. No child wants to talk about, eventually losing their parent. It's always a tough conversation to have, but it's important because we don't want a situation where something happens to you and the children don't even know where to start. And that's where things become very overwhelming. Because aside from estate planning, I also do estate administrations and probate. And a lot of times these phone calls come in from family members who are completely overwhelmed. They've never experienced anything like this in their life. This is the first time losing, someone so close and so dear to them. They don't know what the assets are. They don't know what the debts are. They have no idea where to even look. And that's not a good place you want to leave your children in. You want to make sure that there's a plan, and you want to make sure they know exactly who to call, should you become deceased or disabled. So that's my point on 3. Make sure that, as I said, 3 is kind of tied into 4. You want to make sure your children are informed about everything, about all of your decisions. You want them to know about your assets. You want them, especially if you want to leave more assets to one child versus another, you want to make sure that everyone knows why. Because what typically ends up happening, and I have a few estate litigations where children are suing each other, which is a complete nightmare because they're trying to make the case that one child was heavily influencing the parent and forcing the parent to do all these things. And mom and dad love me more. And there's no way mom or dad would have left you, it's 80% of the estate. Look at everything I've done for them. And things like this can really drag on. And of course, when fights like this continue, you have many, many legal fees. And eventually there's nothing left to fight about. And of course, mom and dad are not there to stop the fight. So it just continues until there's no money left. So things like this, conversations with your children, even if they get along now, because you don't know what's going to happen in the future. I've seen siblings that were just completely inseparable. And then spouses came in between and they became worse adversaries because someone's spouse would say, well, how come mom or dad left you this much and left your brother that much? And suddenly now they're going to other lawyers and getting opinions and trying to figure out how to challenge the will or challenge the trust. And it's a terrible thing. It's a devastating thing to watch a family go through this because losing a parent is hard enough, right? It's the hardest thing you can go through, losing a sibling, a child, anyone in your family. And now on top of losing that person, you now also have to fight with other family about what they left for you to share. Where are we? Now we're at number 5. So number 5 is an important issue to look at because sometimes people have a will, but they don't realize that beneficiary designations actually take priority over the will. So if you have life insurance, and if your life insurance, let's say, names one of your children, and you have 2 other children, and in your will, it says that your 3 children get everything in equal shares, the beneficiary designation overrides the will. And the child who you name beneficiary under your life insurance policy is going to receive the entire policy proceeds. And the children who you named in your will are going to be standing there with their hands in their pocket, not understanding how this just happened when dad said everything is supposed to be divided in equal shares. And I actually have a case just like that, where the dad in his will said that 25% of my estate is to go to my son, who is actually a stepson, but he called him a son in the will. And the other 75% is to be divided between my daughter and her children. And what ended up happening was all of the dad's assets passed outside of probate because they were already beneficiary designations, so the will didn't do anything. So the stepson, ran to an attorney, immediately filed a complaint with the court to have the will invalidated. And now we're fighting this out. And the point here is this. At some time, maybe dad wanted to give 25% to his stepchild, to his son, who he calls his son. But then maybe he changed his mind. We'll never know. But the issue is when you have 2 different kind of decisions, you have something completely different in the will versus the beneficiary designations, that leaves room for the children to argue and to go to court. So you want to make sure that your beneficiary designations are coordinated with anything you mentioned in your will. Otherwise, there's always going to be a question, well, maybe dad didn't realize what he was doing. Maybe he didn't know that beneficiary designations were going to override the will, that the will is just secondary. Maybe he didn't realize, because in this particular case, they didn't go to an attorney. They are the do-it-yourself client. They printed a will template, they went on the computer, They signed it. It was notarized. There was no attorney involved. So they probably didn't understand the consequences, that even if the 25% it said in the will, that all of these assets are not going to be governed by the will. And they didn't realize that. And unfortunately, even if dad wanted to benefit that child, there's no legal remedy. We can't go back in time and rewrite the will. I had another case where a woman was working with an attorney to sign her will, and the attorney prepared the will, and she died before the will was signed. So who survived her? Her husband, who was her second marriage. And now he was trying to take a lion's share of the estate, because under New Jersey law, if you don't have a will, your spouse gets the larger share of your estate. And the interesting part about this case was that the couple were actually already living apart. He had a house in South Carolina. According to some family members, maybe he even had another family there because he was traveling back and forth. So they were already separated, yet because she never signed the will, we couldn't do anything about it. So my best approach to this was to figure out a negotiating tactic, because I knew, the husband who survived, that he was in bad health and he needed money now, to call his lawyer up and say, hey, we can negotiate and settle this. Let us just cut you, a check, a large enough check, so that you leave all of these other assets out of it. And we had a bunch of back and forth, but the surviving husband was desperate for money. So he ended up settling, but he didn't have to. If he was a younger guy, this would have continued forever. And unfortunately, the children would have really sustained this loss, because the guy stood to receive 70% of the estate just by being married, even though they were like two crossing ships. They weren't even living together, the husband and wife. And that's what happens when you don't have a will. So, you don't have to be married a second time to run to do a will, but you should always have one just in case. Good.
我只是要强调他刚刚讲的2点很重要的，就是说，第一点呢，当我们立遗嘱或 trust fund， 我们现在到这个时候，一定要跟小孩子之间有一个好的沟通。OK， 我为什么这样做？我的理由是什么？这是第一点。那第二点呢，就是说你做了以后呢，这个很重要的一件就是说，如果说你光是有遗嘱，可是你遗嘱上面做的事情呢，就如果说呢，你说有一份我有遗嘱，可是呢，所以刚刚讲一直要 update。我要说就是说，如果说你说我有一个人寿保险100万的人寿保险，我就留给我在外面跟什么人生的小孩，那我其他的资产呢，我都要留给我这个自己家里头的2个小孩。如果是这样的情形的话，这个的话就不能够成立，因为你这个外面这个人寿保险呢，它会 take over， 它会取代你的遗嘱。这个例子不好，就是说，如果说我这个人寿保险呢，我要只给我的儿子，可是呢，我的遗嘱说我的资产呢怎么样分配，我要给我的儿子女儿2个平分 ，OK？ 可是呢，你这个平分就不成立了，因为你这个人寿保险呢，已经取代了这个评分这个地方，所以说呢，要常常的去 update， 好不好 ？Yeah, right.
Okay. Yeah.
Yeah.
All right. So I understood everything you said, Audrey. Everything, every last bit. I'm learning a little bit. Yeah, a little bit. Yeah. So I do have another story for you, which kind of falls under point number 6. So for individuals, another common mistake is where the family, the person, the husband or wife, they create a trust, but they fail to fund the trust. So as I mentioned to you earlier, a trust is a legal agreement amongst family. In order for the trust to be a valid document, it has to be signed by the creator of the trust and by the trustee of the trust. But there's a final step. The trust has to be funded. You actually have to take some asset, whether it's real property or cash, and transfer it into a trust. Otherwise, the trust is not going to be alive. It's not going to be a living trust. We just ran into a situation. I was doing estate planning for a doctor, a cardiologist. that had a very unfortunate health situation. He just passed. He had cancer come back like a second or third time. He had his own practice, extremely successful, had a lot of money, no children, okay, no children. And he was married. And the person that he was married to, he did not trust that person to receive, any part of their estate. He wanted to create a certain trust fund for them. But the issue that we uncovered in the planning phase of the estate planning for this doctor is that his mother passed away 5 years ago. And she owned a piece of real estate in Brooklyn that is worth about 2.5 million. It's a multi-million-dollar family home, and they're renting it out to tenants. And it's a very good investment asset. And the entire time he's telling me about this house, and he's telling me, oh, mom had a trust set up and the trust holds the title. And I said, well, do you have a copy of that trust? So he didn't have a copy, but his sister, who lives in Italy, he has a lot of family still in Italy, she sent me a copy of that trust. So I looked at the trust. I looked at the last page, which has the schedule, which shows the assets that are in the trust. And I said, let me try to pull up the deed to the property. So everything looked legitimate about the trust. It was done by an attorney. It was signed. It was notarized. Everything looks perfectly fine. I pull up the latest real property deed, and the deed is the title to the real estate. That is a document that tells the whole world that you own your property. So I pull this document, and what I see is the title, the last deed, is in the mom's name and not the trust. So what ended up happening there was the attorney, like many other attorneys that prepare documents, perhaps they're too busy. They had the document signed, but they never bothered to check whether the person actually transferred the asset into the trust. Now, in my particular practice, I don't close the file until we close every loophole. If I'm preparing the deed and we're sending that to be recorded with the county clerk, we make sure everything comes back. We send the original recorded deed. We make sure everything was completed as intended. In this particular case, this trust was done in 2007. Mom died 5 years ago, and the whole time they're thinking this property is in trust. So I said, I found the deed, and the deed's in the mom's name. So I call up the doctor and I tell him, we're going to have to go to court in Kings County and Surrogate's court, and this could take up to a year in Brooklyn just to transfer title, because that's how busy they are. Okay, so this is the type of situation where someone went to an attorney, created a trust, but never funded the trust. And it happens all the time because some attorneys feel that they're only in the business of preparing documents without actually making sure that everything is done. All right, because if you don't transfer your assets, the trust is never funded, and that's a very typical common mistake. Moving on to long-term care, which is point number 7, which I did talk to you about. So long-term care, just so you understand what this means, there's no real fixed definition. Long-term care can be at home, okay? You may be getting assistance from home health aides. Home attendants are coming to the house to help you with your basic daily living needs. So you're cooking, laundry, bathing, toileting. Someone's coming to help you at home because you are now in a state where you can no longer handle, many of your affairs. Long-term care can be in a more severe kind of setting. If you have persistent health issues, and if you have like an Alzheimer's or advanced dementia, Parkinson's, and you have to go into a skilled care facility, that is where long-term care services are provided. And usually for retirees, you have Medicare, and you think, okay, Medicare has been always paying for everything. Paying for my doctors, hospital visits. I have Part D, my prescription medicines are paid. Everything is paid. The bad thing is when you go into a facility, into a rehab, into a skilled care facility, Medicare doesn't really pay for much. And unfortunately, people learn this pretty late. And then they have to use, as I mentioned to you, their life savings in order to pay for the expenses of their long-term care. Now, what are the expenses? If you are in a facility, like a skilled care facility in New Jersey, you could be paying $400 or $500 per day. All right, we're talking about $10,000, $15,000 a month. And even for many of our clients who maybe are in very good health, maybe in their late 80s, even 90s, still driving, still playing tennis, still doing their grocery shopping. Sometimes folks have a bad fall in the kitchen, trying to reach for something, cleaning. They fall, they break a hip, they break something else, they end up in a rehab. Rehab doesn't go so well, and now they're stuck in a long-term care facility. So when I mentioned to you about these asset trusts and Medicaid, Medicaid is really the best kind of resource to pay for long-term care. But there is a catch. Medicaid is going to look at your assets, as many of you know. And any assets that are considered available, if you have too much, and in the state of New Jersey, what is too much? If you're a single individual, you cannot have more than $2,000 in your name. All right, so $2,000 gets you groceries for maybe a month and a half. I don't know.
我们现在讲到，我们现在目前呢，对我们来讲是确实最重要的。我想在座每一个人应该大概都有 Medicare， 然后有你们的 supplement。那 Medicare 呢，对普通的话，去看看医生啊，这个小病什么都挺管用的。可是如果说你遇到什么大事情，你需要长期的护理的话，不管是在家里的护理人员来，或者是你到这种这个我们所谓的疗养院啊，这个去的话呢，这 Medicare 呢它的所付就很少，所以他现在就给我们讲一个窍门，说我们可以怎么样的去利用这个 Medicare， 就是我们一般讲是这个叫做白卡啊，是不是？就是那个 Medicaid 的话，是一般来讲是通常比较给低收入的啊。那我想我们在座大概没有一个人会可以拿到的，所以他现在就要跟我们介绍一下怎么样可以有效的用到这个，因为刚刚连结我们讲到 trust fund 啊，这 trust account 这些，怎么样呢？把你的资产呢这样子转到那个 trust account 里面，然后可以有效的来利用这个 Medicaid。Medicaid 他刚刚讲说，如果是你是单身的，你每个月的收入呢不能够超过2400块钱。想想2400块钱够什么用？对吧 ？Yeah, okay.
Okay. So it's very important.
Sorry.
I'm almost over, so I want to ask a question first. Okay. Please waste your time. The two questions. One is your estate, below 25 million, you don't have to worry about the trust or something. So I think today you are only addressed to very rich people, anyone above 25 million. Okay.
Mm-hmm.
Now, second question is, if you take a step up,
Mm-hmm.
okay, or you have any account you assign to someone, override a bit the will. Okay, so if you have 25 million, you don't need a will. Okay, the account assignment override the will. Okay. So anyone below that, I don't think you worry. I don't know anyone here have $25 million above. Yeah. Okay. So you have to address that before you're going on. Okay. Yeah. That's 25 million living, no estate tax. If your children don't dispute, like people here, the children are very good, then you don't worry. You don't need a will. Yeah. And again, they step up. If you die, if both parents die,
Right.
then you have no tax involved.
No income tax.
Yeah.
So let me, because you're bringing up three very important questions here. Okay, so there's three questions. So we're gonna for a second put aside Medicaid. So what this gentleman is bringing up is you have a certain exemption from estate taxes. Okay, because estate taxes could be an issue for some people. The good news is when it comes to estate taxes, federal estate taxes. In order to owe federal estate taxes for this year, you have to have more than 13.61 million. Great problem to have. Most people don't have them. As husband and wife, you have double the exclusion. So it's 27 million exclusion as husband and wife. from federal estate taxes. Now, there is a lot of noise in Congress about taking that $26 million, $13 million exclusion and bringing it down to 5 million or 7 million or even 3.5, which is a big fear. Because right now people are like, oh, you know, yes, I have a lot of assets, but I'm nowhere near those numbers. It doesn't mean that they can't change the tax code, that it's not going to affect you later. And usually in the documents I prepare, we add a certain kind of tax planning flexibility that the surviving spouse can do something to the assets so that we don't get hit with estate taxes on the second death. So the exclusions are high for federal, yes, but New Jersey, like New York, like Pennsylvania, also have an estate tax system. They have their own estate taxes. Right now, New Jersey, their estate tax is zero. They can't bring it back. If we go back to 2015, 2016, if you die in New Jersey and you had more than 675,000, there was a New Jersey estate tax. Okay, right now, I don't want to say they repealed it, they didn't, they could always bring it back. New Jersey does have something called an inheritance tax, which applies to beneficiaries who are not your spouse, children, or grandchildren. So if you're leaving money to your siblings, nieces, and nephews, there's going to be New Jersey inheritance tax. And as Audrey and I just talked about, it doesn't matter where those beneficiaries live. They can live in Taiwan, there's going to be an inheritance tax if they are not a spouse or child. So it's important because the tax is about 16% on the sliding scale, and you know that's a pretty good number. Some states like Pennsylvania, for example, have an immediate a 4% tax. So when you pass away, everything is counted and there's a 4% tax. In states like New York, you have to have more than over 7 million to incur New York estate tax. Now you mentioned also, sir, a step up in basis. Okay, what we're talking about is we're not talking about estate taxes, we're talking about income taxes. So for most of us who purchased, let's say most of us in a room, if you purchased real estate and you purchased it more than 10, 20, 30 years ago, the real estate has really appreciated in value. Okay, just by way of example, let's say you bought a house for 100,000 and today it's worth $1 million. All right, you have a profit, you have an appreciation of 900,000. If you sell the property today as husband and wife, you can exclude $500,000 against capital gains tax. That's income tax. So in the case where you purchased it for 100 and you sell it for $1 million during your lifetime, as long as you sell it for less than 600, you're not paying any capital gains tax.
But
If
if
you-
you die, you don't have to pay. Right?
Well, capital gains tax is different because capital gains tax, it's a tax liability that comes into effect when you do something. You have to sell the property. Estate tax comes in as soon as the person dies. And you mentioned beneficiaries override the will. That's something separate. That has nothing to do with taxes. That is just a question of the intended beneficiaries are going to receive the assets, or the beneficiaries you designated in your will are going to receive the assets. So it doesn't matter. If you held the asset until death in your name, whether you have a will or not, that asset's going to get a step up. So in the same example, if you bought the house for 100,000 and you held the title in your name and you pass away, the property gets a step up in income tax basis to $1 million. And if your children sell it for $1 million, they're paying zero capital gains tax. So that's what the step up means. Now, when we prepare the trust that I mentioned to you earlier, folks get nervous because they say, well, wait a second, if I put my real estate into a trust, am I going to get that same step up on death? Well, it depends on the kind of trust. The trust that I prepare for IRS purposes is considered a grantor type trust. What does that mean? That means the IRS still treats you as the owner because in your trust, you maintain the rights to change trust beneficiaries. You maintain the rights to income and other different rights so that for IRS, we're still treating you as the owner. Okay, but for Medicaid, we're not, as long as it's been more than 5 years. I hope that answers the question a little bit. Yes? I said, I hope it answers the questions a little bit. Okay, but again, estate taxes and income taxes are completely two different animals. And for the majority of my clients, it's income taxes that we're worried about. Because estate taxes, you have to have, like I said, over $13 million. It's not a problem. Income taxes is a problem for people whose assets have appreciated. If you have stock, if you had Apple stock, and you purchased much of it in the 90s and it appreciated, if you sell it today, there's going to be capital gains tax.
They have stepped up. What do you mean?
What's that?
They have stepped up,
It steps up to the value as of your date of death.
When you sell, okay.
It steps up to your date of death value.
Well, don't misguide everyone here.
Okay. So that's just taxes. If anyone else has any questions about taxes, because
I have
yeah.
a question. What's the New Jersey state tax upon the death?
So estate tax right now is 0. We're not paying New Jersey estate tax.
My friend, her husband passed away, and then she went through a probate, and then she told me, I'm not quite clear, but I got the impression that she did mention that no matter what they did, they're going to take certain amount of money from you.
Take or tax?
They will deduct certain amount.
No. So as long as the beneficiaries are immediate family, such as your spouse, your children, there's no inheritance tax. Grandchildren too. Stepchildren also are exempt. So if you leave assets, there's no inheritance tax. But anyone else who receives assets, there's an inheritance tax. And it's worse than that. If you made a gift of the asset 3 years before your death, they pull that back in for inheritance tax purposes. So if you gave away $100,000 to a niece or nephew a year before you died, there's going to be an inheritance tax on your death.
How many years?
As long as if it's within 3 years of death. If it's more than 3 years.
5 years? 3 years?
There's a 3-year clawback on gifts in New Jersey for inheritance tax. Yeah, if it's 5 years, then no, a gift is a gift. The only thing with gifting is, as many of you may know, you can gift a certain amount for federal tax purposes. So this year you can gift $18,000 to any individual without having to file a gift tax return. So you don't pay gift taxes. You just have to file a return if you gift someone more than $18,000. Husband and wife can gift up to $36,000 to any individual donee, child or anyone. Okay. Yes. Okay. So yeah, if anyone has to go, I know we're going overtime. You guys can take off. I'll stick around just to finish up. All right. If any of you, like I said, we don't get to the questions, you could always email or call. All right. So that's essentially long-term care. I'm just going to leave you with again that it's long-term care is for everyone, and Medicaid is certainly not just for the poor. I qualified many clients that were very well off. And, the best thing the state can do for you is give back. After all the taxes you've paid through the years, you deserve a health insurance that covers long-term care. All right. Number 9, we were talking about gifts. So one of the common mistakes is, question?
Can you give us an example of how to deal with the Medicaid case?
A Medicaid case? All right. I have a Medicaid case right now. And it's actually a very complicated one because I had a mother that came to me for estate planning a year ago. We prepared an irrevocable trust for her a year ago, okay? And the purpose was, as long as it's been more than 5 years, her home, which was worth $1 million, will be protected if she doesn't need Medicaid in the next 5 years. Well, what ended up happening was her husband, who she's married to, but they are estranged, he ended up in a nursing home this year. So the son called me up and said, I know that, you specialize in this, but I think because my parents have been technically separated for 10 years, we have to file for a divorce right now because they're going to look at my mom's assets when we're filing for Medicaid for my dad. And I said, that's absolutely true, because when you file for Medicaid, they don't just look at your assets, they look at the total marital basket. And this is a much bigger issue for people who are married a second or third time over, because your assets are potentially going to be vulnerable to the Medicaid expenses of your spouse. In fact, in the state of New Jersey, Your spouse's debts are your debts. You're responsible for them. So in New Jersey, they have something they call a Medicaid divorce, right? And the reason why they call it a Medicaid divorce is because they know people get smart and they try to file for a divorce and then they file for Medicaid. So the state Medicaid program said, no, not so fast. If you file for Medicaid in 5 years, from within 5 years of your divorce, we're just going to assume that the only reason you had this divorce done was to file for Medicaid. And we are going to deny you Medicaid. So when he came to me telling me, let's do a divorce proceeding now, I said, absolutely not. Because number one, that is already in the nursing home. Even if we file for a divorce proceeding, it's going to take many months. You're going to have to pay private at the facility for many months. And on top of it, mom's health became much worse. Her dementia, before she was kind of having signs, but she was still perfectly there when we did the trust. Her dementia became much worse. And now, even though she has a power of attorney, you cannot give rights to an agent under a power of attorney to do a divorce for you. That is illegal. So your rights to a divorce are personal to you, and you cannot delegate that to anyone. So knowing what I know about the family, I knew a Medicaid divorce is not even an option. So what did we end up doing, which we're in the middle of right now? Mom owned, as I said, the house. We transferred the house into a trust. The trust is no longer good because I know that we only did it, it's only been a year. So unfortunately, I had to revoke the trust. We had to transfer the asset back into mom's name just so we could file for Medicaid for dad. Because with mom owning the real estate in her name, the Medicaid program doesn't consider the real estate. If I left it in trust at the moment, it would have been a problem. So I had to undo what we did. And then in order to protect the equity in the house, we made mom sell the house to her son. Okay? So she owned this property, and I'll just put a value. Let's say the house was $500,000. The son gave her $500,000. And for this day and age, dad, who were filing for Medicaid, he can only have $2,000. The spouse who's not in the nursing home can keep 1/2 of the total marital assets up to $150,000. Anything more than $150,000, we have a problem. We have to spend the assets down. So what do? In New Jersey, there is something called Medicaid annuities. So any of you who are familiar with IRAs, deferred tax annuities, your typical retirement assets, Medicaid annuities are a little bit different because they pay out immediately. So in the state of New Jersey, you can take all of your assets, and someone has to be in a nursing home already when you do this. Timing is important. You can take all of your assets in a married setting, so husband and wife, and you could put them in a Medicaid annuity, and you can have that annuity pay income to the healthy spouse. And you can get Medicaid for the ill spouse who's in a nursing home. So what we're doing here is mom sold her house to the son. The $500,000 she received, we are now taking $350,000 of that, the excess, and we're putting it into this annuity so that the annuity can pay mom $15,000, $20,000 a month. Medicaid doesn't care about the income of the healthy spouse. So we are able to protect $500,000 with this kind of strategy. If we did nothing, dad would continue to stay in a nursing home, and eventually the nursing home would sue the mother and come after the house completely. So the important thing is it's a very complicated kind of Medicaid application. They're not always like that, but why do people, you may be asking yourself, why do people stay married if they're not speaking to each other for 10 years or whatever the case may be? It's always an interesting situation. And a lot of times the answer is really because they can't survive on one income. Both husband and wife are living on Social Security, pension, and even though they can't stand each other, they're sworn enemies, they need each other to financially survive, but they don't realize that once one of them becomes chronically ill, if either of them own assets, it's going to be a problem if they didn't do the planning in advance. So that's a typical, Medicaid case. Usually, we're filing for someone who is already a widow or a widower, and our options are even more limited. We can still utilize the annuities. Of course, it's always nice if I already have a trust like this that was done 5 years ago, because then we know that the house is exempt. They can't touch the house. They can have $1 million investment asset in the trust. If it's an irrevocable Medicaid asset protection trust, if it's been more than 5 years, the Medicaid program can't reach it. So with all of this Medicaid planning, sometimes people get nervous and they don't go see an attorney. They just do some Google research and they decide, wait, if I gift my house to my child now, and if I need Medicaid or if I become ill, it's already in my child's name, so they can't come after it. Well, the problem with that is that now this is your child's house, and if your child has a divorce, half of your house you can lose to their spouse. If your child has a bankruptcy, you can lose your house completely, or if your child is sued, God forbid they're in an accident, they're found liable. So there are so many risk factors with why trust planning is so much better than gifting assets to a child. The other issue is taxes. We talked about step up in income tax basis. I want to go back to that example where you purchase a house for $100,000 and it's worth $1 million. If you gift that property to the child takes your tax basis of $100,000. So if they sell it, they have a $900,000 profit. And that's the major issue there. If you held the property in your name or in a special kind of trust, it would get that step up to $1 million. And I've had a case like this in Brooklyn where it was actually advice from an attorney that someone's grandma received and transferred her Brooklyn house that was worth $2.7 million 3 months before her death to her granddaughter. And because she purchased this property in like the 50s, it was worth close to nothing. And the family wanted to sell the house. And when they sold the house, they had to pay like $1 million, like almost $1 million in capital gains tax, all because she transferred it before she passed away. So making large gifts is never a good idea for long-term care planning, for Medicaid planning, and it's definitely not a good idea for income tax planning. I'm not saying all gifts are bad. It just really depends on the circumstances. I'm sure you have, children, grandchildren, you want to gift them money so that they can put a down payment on the house. You want to make a $10,000, $20,000 gift so that they have money for a wedding. But at the end, you don't realize how potentially this can affect you later. So we do want to be careful when we're making gifts. The last point is,
I'm seeing a lot of people that just give their house or all their assets to distribute to their children so they can they can use the Medicaid or they can move to the, government's, the government subsidized.
Right, so they can get Medicaid to pay for their, yeah.
What you say is not a good idea.
If the person already made the gifts and it's been more than 5 years and they're going into a skilled care facility, at that point, yes, it doesn't matter because they already have a roof over their head.
Okay.
If they live in their own home and they're titling their real estate into the child's name, there's a lot of risk factors there. There's a lot of issues. I talked to you about nursing homes. I didn't talk to you about assisted living facilities. And if you've ever been to an assisted living facility, it's nothing like a nursing home. Assisted living facilities are like resorts. Nursing homes are hospitals. I mean, that's basically what they are. Some of these assisted living facilities I've been into, I would move in there if I could, because it's so nice. They have a fine dining, they have live bands, they have all these activities. The issue with assisted living is if you gift all of your assets, you will never be able to get into an assisted living facility because when you file an application, you have to show them that you have enough money to be able to pay your way. And if they don't see financials with money, unfortunately, assisted living is no longer an option. Now, the great news about the state of New Jersey is that Medicaid can actually pay for assisted living. Yes, but you have to do something at the moment you are admitted to the assisted living facility. You have to engage into a contract with them where you tell them that you promise to pay private out of pocket for the first 2 years or 3 years, depending on the facility. And then they have to make a Medicaid room, a semi-private room, immediately available for you. And then you can file for Medicaid, and Medicaid can pay for your assisted living. And this is something that many people don't know, because in most other states, Medicaid does not, in New York, Medicaid does not pay for assisted living. And you are completely paying everything private. So when you divest yourself, when you move away all of your assets, you don't necessarily want to do that because it eliminates many of your options, many of your, housing options. You want to keep certain assets in your name because you may need the cash. You may live another 20, 30 years and maybe Social Security and your pension alone is not enough. So when people come to me and they have a house and maybe they have 500,000 in liquid assets, I'm not very quick. I don't usually tell them, hey, let's put that in the trust, because when you put an asset into a trust, you can't touch it anymore. That's the whole point of Medicaid planning, so that later, if you ever do need to file, you tell them that the property is unavailable to me, I can't reach it legally, therefore it's unavailable to you. And that's essentially how this kind of Medicaid planning works. And again, we're talking about Medicaid. You may live your whole life and you may never need to go on Medicaid. You may die of natural causes in your sleep. So what's the point to this kind of trust planning? What's the point? The best way I look at this trust is the trust is like an insurance policy, like fire insurance. If there's a fire in your house, you better have it. If God forbid you need to go into a skilled care facility, you better have that trust in place. In that Medicaid case where I told you where the wife had to sell the house to her son, no one imagined their father having a stroke earlier this year that would have completely disabled him and ended him in a nursing home before the wife. The father was in much better health than the wife was, and no one would ever imagine. So it's always kind of worst case scenario kind of planning, because we don't know. We don't have a crystal ball. We don't know who's going to become ill. And because of all of these question marks, we create this kind of trust in advance. Because again, Medicaid isn't free. Public assistance is not free. They do look at your assets. They do look at your income. So the more you plan, the more you get ahead of this, the more money you're going to save in the end. And the more, is going to end up going to your children, the more of your legacy, the more of your wealth. Because that's the ultimate goal here. Maybe your children are well off. Maybe they're not. At the end of the day, you want to make their lives better as a parent. I mean, that's really the last thing you want to do on this planet before you check out. So that's kind of estate planning, long-term care planning in a nutshell. I'll take questions if you have it, but I think we're wrapping things up. Audrey, if you want to jump in and give any final remarks in my new language.
You're going to speak Chinese next time
So
you're here,
yeah, I'm
right?
gonna have to learn quick.
我想大家都应该听得很清楚吧，因为怎么讲呢？这实在是一个对我自己个人感觉，这是一个当务之急。OK， 我们常常呢就会说不去想这些事情，可是呢其实是蛮重要的。我希望今天他的演讲呢对大家有所帮助，因为我第一次跟他交谈的时候，哇，我真是茅塞顿开，可是也不能说我完全都懂他讲的是什么。如果说你们想要更了解，想要更了解这方面，对你自己息息相关，因为每个人的 case 不一样。如果说你有想更知道一点、了解一点，怎么样去对自己的生活、对自己的规划、对自己的未来，为你自己的儿女有所做一个计划的话呢，他的 office 就在 Randolph。我想他今天跟我们的那个 folder 里面也有他的 contact information， 你也可以给他 email 或者打电话给他的公司。对，那是他的名片。我认识他，因为我觉得他的背景，他18岁到美国来，他是一个怎么讲？他是一个乌克兰的犹太人，所以他们从小在皇后区长大，那父母呢也是很好的，然后他也相当努力，很认真的做什么事情。我跟他认识也有10年了。Have we known each other 10 years?
Since 2017.
2017呀，这样呀，所以也有一段时间，所以对他也蛮了解的。希望今天的他今天所讲的对大家有帮助，好不好？我想我们回去都可以多思想一下，求神呢怜悯。
So you will give us a free consultation, right?
Of course, free
Yes.
consultation. And just lastly,
For
so
how
I
many
don't.
hours?
What's that?
For how many hours?
I don't cut my time. You come in, we talk about your family, your assets. I make some suggestions, and and you decide if you want to move forward. And I don't speak Chinese, I don't speak Mandarin, I do speak Russian. I was
We
born
can bring our AI
Yeah.
so we can translate directly.
Yeah, so if any of you speak Russian, I could also kind of jump onto that frequency. But yeah,
Thank you.
Thank you
for
so
spending
much.
your time with us. And also, we do record your lectures today. Okay, so is that okay? We share with everybody in our group.
that's perfectly fine.
Okay, good. Thank you so much.
I'll
okay.
send you a bill later for the bid.
Okay, send it to Audrey. Okay, thank you.好，大概小我知影了啦，哈啊，有没有用那么我们也不知道，对不对？但是多一些知识哈，东西较好啦哈。多谢哈，啊多谢，今仔较济时间哈，啊，但是律师甲咱讲遮久，咱嘛先值得啦哈。
我有一个朋友，他本来没有做，后来他做两种都做，所以好处很多。我想大家大概都知道他们的 family， 然后儿子死了，然后妈妈就紧张了，所以妈妈就做这两个 ，one is will, one is the trust。Very important for us too.
嘿，所以咱咧有赖吼，大家会使当你的赖内底分享你家己吼，你家己经验是啥物吼，啊，大家互相 share 你的 experience 吼，多谢多谢 ，OK， 好啊，拜托大家若到对收倒啊起来吼，好，好，谢谢。